We have folks that are on the line with us tonight, waiting to speak with you, gentlemen. Let's first go to Blake from Birmingham. Blake, we appreciate you staying up late with us tonight. If you will, go right ahead with your question.
In regard to drug manufacturers' recall or product defects, such as medicine, who sets the determination if that is going to be a class action lawsuit, and what limitations are there placed and who's in charge of that on the actual damages that can be awarded in regard to drug recall cases?
Yeah, that's a lot and a good question.
Yes, yes.
Yeah, so drug recall cases, we see, if you watch TV at all or listen to the radio, you're gonna hear about different drugs that are recalled, or they may not be recalled, but there may be some litigation about those drugs. So I think your first question dealt with whether or not it's going to be a class action. So what happens in these cases is you have so many similar cases throughout the country. And so in the state of Alabama, for example, there may be 5,000 of a certain type of drug case, but there may be 50,000 or 100,000 in California, and then all throughout the states. So what will happen is those cases will be consolidated in multi-district litigation. It'll be taken probably to the drug manufacturer's home state, and that's where those cases will be consolidated, and you may have 100,000 cases in one particular court. And so what happens then is, as the cases are litigated, they're all very similar in the liability aspect, but they're also similar in what damages they cause to the customers or to the patients. So then after a period of time, everyone makes their damages claims, and it does take a lot of time. And eventually, those damages claims are adjudicated, and offers can be made, okay? And those offers are usually similar, okay? So if someone has one particular type of injury, they'll be put in a certain class or category. And then throughout the process, you'll have everything from the most severe to the least severe, okay, and everything in between. And so those offers are made according to how badly the injury is categorized, or how the injury is categorized. Now, if you choose not, and your lawyer will present those to you, those offers to you from the manufacturer. If you choose not to take that, well, it depends on how severe your injury may be. If you've got a really significant, severe outcome, serious injury or death to a loved one, then that might be something that we recommend. You don't need to take that. We need to go it alone, and we need to go directly against this manufacturer, and you can do that. But if it's a situation where they're offering a fair amount of money, because that's all you can do, you can't make it, you can't undo it. If they're offering a fair amount, well, we may recommend that you take that and close your case out. But let's say that it's an insignificant amount of money, an insignificant offer. Well, it may be a smaller type injury. Then we have to weigh whether or not it's worth actually going forward, because the squeeze may not be worth the juice, as they say. So you would end up not getting anything if you went through the process, just like Kirby talked about earlier. They always have to have experts. They always have to have very expensive litigation that goes along with it. So we just help walk everyone through that process.
And Ken Blake asked about some defenses, and there's some surprising defenses in these drug litigation cases, aren't they, involving FDA approvals and things that might surprise some people?
Yeah, there are a lot of hoops you have to jump through. It comes with the territory. Okay. But you may have a situation where you say that you took a certain drug, but it may not be a prescription drug. It may be an over-the-counter drug. Well, you got to prove that you actually took the drug. And you got to prove that you took enough of it to cause the problem. So that's just one thing. Okay. So I think, like Kirby mentioned earlier, you need to save all your stuff. Yeah. You need to be able to prove that you own the product, and that you use the product a certain way. So, that's good. But there's ways that we can do that.
That's good. Well, Blake, thank you so much for calling in with your question tonight.